All rise. Please be seated.
Kosovo Specialist Chambers is now in session.
Good morning, everyone, and welcome in and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is file KSC BC 2020-04, the Specialist Prosecutor versus Pjetër Shala.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the SPU. Mr. Prosecutor, please.
Good morning, Your Honor. Today, for the prosecution, appearing Bernard Kushnik, Associate Legal Officer, Margot Portier, Associate Legal Officer, Valeria Bolici, Prosecutor, Moira Van de Poel, Intern, and Filippo De Minicis, Associate Prosecutor.
Thank you, Mr. Prosecutor. And now let me turn to the counsel for victims. Mr. Laws, please. Mr. Laws, your microphone is muted, I think. So there is a problem with your voice. No, we still can't hear you. I see that your microphone is muted on the screen, it seems. And now your microphone is not muted on the screen, but I can't hear you. So let me turn to the AV booth. Madam Court Officer, can you check if the audio connection can be set up? Thank you. Mr. Laws, can you hear me? So apparently there is a connection problem, so our technicians are going to work on it in the following minutes. In the meantime, can you let me know if you agree that I introduce you? You're Mr. Laws, you're the counsel for victims, and you're appearing alone on behalf of the victims today. And I see that you're nodding and that you're approving. Thank you, Mr. Laws, and we'll do our best so that you can speak in the following minutes. But in any case, I can already see that you are connected with the audio, so you hear the hearing, which is for the moment the most important. Let me now turn to the defense. Mr. Gillissen, please.
Thank you, Mr. President. I'm Mr. Gillissen from the Bar of Liège. I'm here with Mr. Arwini, co-counsel of the Shala's defense team, and Mrs. Kurasek, who is our case manager. Thank you very much. Oh, and of course, Mr. Shala is with us by video link. Okay, thank you.
Thank you, Mr. Gillissen. Mr. Shala waived his right to be present and is indeed with us via video link this morning. Let me turn to the registry. Mr. Nielsen, please.
Good morning, Your Honor. Good morning, colleagues. Jonas Nilsson, Judicial Services Division in Registry.
Thank you, Mr. Nielsen. And for the record, I'm Nicholas Guillou, pretrial judge for this case. On 31st March, I scheduled the 7th status conference in this case. My goal today is to organize the transmission of the case to the trial panel. In particular, I wish to discuss disclosure of evidentiary material, translations, the status of the SPO's investigations, the status of the defense investigations, the points of agreement on matters of law and fact, and finally, any other issues the parties may wish to raise. I thank the parties for their submissions, and as usual, I invite the parties to present their views in a concise fashion about each item on the agenda, which I will address individually. But before the matters included in the agenda for today's hearing, I would like to address one preliminary matter. In filing F00171, the defense indicated that following the Court of Appeal's decision of 11 February 2022, it inquired into the government of Belgium's willingness and capacity to implement the conditions of provisional release. It proposed through the Defense Office coordination and the registry. The defense further indicated that it was notified by the immediate office of the registrar of the response by the Belgian Federal Minister of Justice on 30 March 2022. However, the defense has not attached the aforementioned correspondence to its submissions on the review of Mr. Shala's detention. I intend to order the defense and the registry to file this correspondence on the record for the purpose of the next detention review. And before that, I would like to ask the parties and the registry whether they have any submissions to make in this regard. Mr. Gillissen, please.
I'm really sorry, Mr. President. That's my own fault. Really, I'm sorry, and we are making very fastly what we need to do. I'm sorry.
No need to be sorry, Mr. Gillissen. It can be cured very easily. Mr. Nielsen, do you have any submissions on this?
Thank you, Your Honor. No submissions from the registry on this. Thank you.
Thank you, Mr. Nielsen. Mr. Prosecutor?
No submissions from this prosecution, Your Honor.
Thank you, Mr. Prosecutor. Having heard the parties, I will now issue my first oral order. I order the defense to, in coordination with the registry, file the correspondence with the Belgian authorities regarding their willingness and capacity to implement the conditions of provisional release of Mr. Shala, and, if applicable, any related correspondence in the record by no later than Tuesday, 19 April 2022. In the event that the aforementioned correspondence and any related correspondence was addressed to the registry, I order the registry to file any such correspondence in the record by the same date. Furthermore, in view of the nature of the information under consideration, these filings shall, if necessary, be classified as confidential. Furthermore, I order the registry, defense, and the SPO, as the case may be, to file public redacted versions of the following filing relating to the review of Mr. Shala's detention by no later than 20 April 2022. And this is for filing F00152, F00171, and F00177, and finally F00184. This concludes my first oral order. Let's now move to the first topic that was listed in the scheduling order, which is disclosure. As usual, I will give the floor to the parties on the disclosure of each category of evidentiary material separately. First, the Rule 1021B material, which is the material the SPO intends to present at trial, then the Rule 1023 material, which is the material relevant to the case as listed by the SPO, then the Rule 103 material, which is exculpatory material, and finally the Rule 107 material, which is protected material for which the consent of the provider is requested. Let me now move to the material the SPO intends to present at trial. In its written submissions, the SPO indicated that it has completed its Rule 1021B disclosure, with the exception of some items that are withheld pursuant to judicial authorization and will be disclosed once the relevant protective measure expires. The SPO also indicated that it will be disclosing some translations of items under this category further to a request by the defense, lesser redacted versions of some statements, and a revised transcription and translation of the English version of the accused SPO interview. The SPO argues that none of these disclosures amount to new evidence, so the disclosure of Rule 1021B material should be considered finalized. However, the SPO is still looking to add additional material for the presentation of its case. The SPO filed a request pursuant to Rule 1022, seeking leave to disclose transcript of several witness interviews. The defense opposes the request, arguing that the SPO has not shown good cause for interviewing such persons and putting them forward as proposed witness at such late stage of the proceedings. The SPO also indicated that because of recently completed investigations, it would need to submit still person to Rule 102.2 the statements of one additional witness. At this stage, according to the SPO, those material cannot yet be disclosed because a variation of protective measures is first required from a third-party entity. Once this variation has been obtained, the SPO indicated that it would file an application pursuant to Rule 102.2. I will not rule on this Rule 102.2 request orally today, as I want to issue a consolidated decision with the upcoming request from the SPO. I would therefore ask the SPO when it intends to file such a request, hoping that it will be in the following days. I do not intend to entertain such requests after the end of April. The SPO case cannot be constantly evolving. I also invite the SPO to confirm that no other Rule 102.1b material is to be disclosed and to give a timeline for the population of witness entities on legal workflow, notably if it will complete this prior to the beginning of the trial. And finally, I invite the defense to make any submissions regarding the completion of witness entities in legal workflow and how this impacts its ability to prepare for trial. Mr. Prosecutor.
Thank you, Your Honor. In addition to our written submissions that Your Honor has accurately summarized, we can update Your Honor on the status of our Rule 102.2 application that we cannot file yet for the reasons summarized by Your Honor. We have obtained, we have already taken the first necessary steps. We obtained the consent of the interested parties, and we have started preparing the required motion, which we believe, we are confident, we will be filing next week. Then, Your Honor, it depends on the time that the third-party entity will take to get back to us with regard to our ability, to disclose these additional statements as we submitted in our written submissions. We can assure Your Honor that the material is limited in its both quantitatively and qualitatively. It concerns one witness, and it is, for the reasons we explain in our written submissions, very limited in scope, and so we don't foresee that this will create the need for any delay that could cause concern to Your Honor or to the defense. With regard to our the witness entities, as asked by Your Honor, we have so far populated 10 witness entities out of 15. Now, of course, if Your Honor will be granting our Rule 102.2 motion that we have already filed, and possibly the one that we will be filing, then there will be additional witness entities to add. But we will certainly complete that process before the start of trial, Your Honor. And I believe I have addressed all the points that Your Honor requested at this time.
Can you confirm that there is no Rule 102.1b items to be disclosed?
Yes, Your Honor. As stated in our written submissions, there isn't. We're just trying to, well, for example, today we will be disclosing some translations, 6 translations of Rule 102.1b material. It's actually 4 translations and 2 transcriptions of videos that were requested by the defense, and so we will be disclosing them. But there is no new material, to our knowledge, that needs to be disclosed pursuant to Rule 102.1b, Your Honor.
Thank you, Mr. Prosecutor. Mr. Gillissen, please. Mr. Yayouni.
Good morning, Your Honor. Thank you very much. Before we address this point, may I raise a preliminary point on the oral order Your Honor has made, if I'm allowed. We can get to it a little later, but we can deal with it right now before Mr. Gillison makes any submissions on the points of 101 and 21B.
Please proceed.
Thank you, Your Honor. Simply to say, Your Honor, tomorrow and Monday will not be working days, and we are busy at this stage preparing, finalizing a motion, a referral that will need to be filed today, which would certainly take us to the late hours of today. And next week we have a deadline for a certification for appeal. For the 20th. So if we could seek your leave to move the deadlines Your Honor has put on oral order on page 4, line 17 to page 5, line 11, into at least the end of that week, meaning the 22nd of April, to allow us to, at least for the public redacted versions, to be able to deal with them properly after we have submitted those other findings. Thank you.
Mr. Leone, just to be clear, your request is about the last part of my oral order, i.e. the public redacted version of your submissions, not for the filing of the correspondence with the Kingdom of Belgium, correct?
Yes, Your Honor. We're pretty confident we will be able to file the annex. Not too much substance that needs to be put in. We will annex the folds we have the 19th to do that, and we can manage to make our certification within those 2 days. So it's about the public redacted versions of the 4 other filings that need to be submitted the following day, just to do it properly, Your Honor. Thank you.
When would be? When do you think you can finalize the public redacted version?
Yeah, by the end of the week, Your Honor, the 22nd, so it's 2 days more to be able to deal with them after we finalize other submissions.
Thank you, Mr. Ayuni. I will deal with that later in the hearing, but I will most likely amend my oral order. Now you can proceed with the submissions on the Rule 102.1b material and the Rule 102.2 requests, please.
Thank you. Mr. Gillison will deal with these. Thank you.
Thank you. Mr. Gillison, please.
Thank you very much, Your Honor. So, about the disclosures, point A, we take note about what told us Mr. Prosecutor. I have almost nothing to add, but just one thing. We have a request to add 4 witnesses and the evidence. I'm sure my colleague understands perfectly well the point. That's really the only thing I have to say. About the point B1, we requested from the SPO the communication of 580 items issued from the notice pursuant Rule 1023.
This will be dealing with the next item, Mr. Gillison. Now, if we can just focus on the 102.1b and the 102.2, not what's in the notice, please.
Okay, so that's all.
Thank you, Mr. Gillison. Mr. Prosecutor, do you want to add anything?
No, thanks, Your Honor.
As usual, I would appreciate if your request could be filed as soon as possible. I understand the constraints you have with the third party, but if you are not able to file within the next, I would say, 2 weeks, I would appreciate if you can inform me, because then I will not wait for this to rule on your first 102.2 request.
By all means, Your Honor, we'll keep Your Honor informed.
Thank you, Mr. Prosecutor. Let me now move to the next topic in our disclosure item of the agenda, which is the disclosure of evidentiary material relevant to the case, which is the Rule 102.3 material. The defense submitted an inter partes request with a list of 580 documents selected from the SPO Rule 1023 list, recently updated with partially revised descriptions. The SPO, if I'm not wrong, disclosed the first batch of the documents requested by the defense yesterday evening. However, the SPO indicated that a significant number of the remaining documents are yet to be reviewed and processed for disclosure, that the defense also requested items that do not have revised descriptions and that could have been requested earlier, and that a substantial number of documents that form part of the defense request will lead the SPO to seek protective measures. I invite the SPO to give a timeline for their protective measure request and if it can be filed before 6 May. I also invite the SPO to confirm that it will not dispute the materiality of the documents for the defense. However, before giving the floor to the SPO on this point, I also note that beyond the disclosure of material that are currently in the Rule 1023 notice, the SPO is also asking to add new items to the list itself. In filing F00170, submitted on 25 March 2022, the SPO seeks leave to amend its notice submitted pursuant to Rule 1023 of the rules with 3 categories of documents. The first category concerns 13 documents for which their Rule 107 status has been resolved in a manner which now enables their disclosure. The second category concerns the ruling on the confirmation of the indictment and admissibility of evidence in another case dated 24 November 2010 and the record of the hearing on the confirmation of the indictment in the same case dated 22 October 2010. And the third category relates to pictures of several witnesses which were requested by the defense. In filing F00176, submitted on 6 April 2022, the defense responds that it does not oppose the SPO request, but emphasizes that it will need to be allowed sufficient time to review and analyze the proposed additional documents as well as the entirety of the material disclosed by the SPO. I stress that the documents falling in the second category are from 2010, which is 12 years ago. I invite the SPO to explain why they had not been included in the SPO's notice under Rule 103 before. And finally, I note that in its written submissions, the SPO indicated that it intends to make an oral application during this hearing to amend again its Rule 123 notice with one more document. So I invite the SPO to present its requests now and to justify why we are still discussing the Rule 1023 list at such a late stage of the pretrial proceedings. I also invite the defense to respond to the SPO request orally, as I intend to issue an oral order on the 2 SPO requests to amend the Rule 1023 list at the end of the hearing today. Furthermore, the defense indicates that it is unable to take a definitive position regarding its intention to object to the admissibility of evidentiary material that has been disclosed on the basis of Rule 1022 of the rules, and expect to be able to do so after the prosecution disclosure is completed. I invite the defense to specify whether it has taken a position regarding any objections to the material already in its position and whether it can give any further indication as to when it expects to file such objections, if any. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. So as per your first question, we believe that we will be able to file our protective measure motion by the 6th of May, as requested by Your Honor. As for the materiality of the items requested by the defense, Your Honor, we would like to finish the review first at this point in time, not having finished the review, we are not in a position to state whether we will take issue with the materiality of these documents.
Sorry, Mr. Prosecutor, would you contest the materiality for the defense of the documents? Are you also able to file any request before the 6th of May?
Yes, Your Honor, we'll do our best to do so, should we decide to contest to object to the materiality of any of the requested items.
Thank you.
Now, with regard to the request for amendment of the Rule 1023 notice and the 3 categories identified by Your Honor, I will focus on the second category, which Your Honor has specifically requested about. Your Honor, these are documents which are devoid of evidentiary value. We understand they should have been included in the list originally. That case file is a large case file, and we have reviewed it also further to the defense requests, for example, the status conference in January, to have the complete file in order to be able to navigate it more easily. And so we've conducted further reviews, and that's why these documents have been included just now. With regard to the rest, to the remaining items in that request, Your Honor, I just would like to note that some of them were specifically requested by the defense. These are the third category that has identified, that Your Honor has identified, and so that's why we have included them there. Now, with regard to our announced oral request, I do make this application now to add item with ERN SITF 000-14574-000-14576. This item was also discovered further to a review of the case file of a previous case that dealt with there was some overlap between the case and the facts charged in this case. And we've now completed that review. And it was a large case file, and we're now confident, we're now ascertained that every document contained therein was either we either gave notice to the defense or disclosed it to any through other rules. And this document remains outstanding. It's a 3-page record, Your Honor, where the suspect exercised his right to remain silent. And so we request to be able to amend our list with that document as well. So if the defense chooses to do so, they can request it. And I believe this answers Your Honor's questions.
Thank you, Mr. Prosecutor. Let me turn to the defense. Mr. Gillissen, please.
Yes, Mr. President. As I told you just before, we asked for the communication of 580 items. We received yesterday some of them. So we didn't receive yet all the documents, but however, we know that this communication will be on no issue. We will have, I'm sure, the communication as soon as possible. So this is the first point I would like to focus on. About the point B2, I just have to take note, Mr. President, I think so. And for the other point, normally all seems to be all right. Everything seems to be in order. I can add for the completeness that we share with the SPO a full board, as you know, concerning any pending issues like translations, missing documents. And if some small problem should still arise, this procedure will enable us to resolve them without having to resort to the chamber, which is undoubtedly a great advantage and a precious saving time for all of us, including you and the chamber, of course, Mr. President. So I don't know if you want to that I address other point. You told about admissibility. I'm ready to explain it. So I can say that we are already in a position to state our intent to object the admissibility of some material that has been disclosed on the basis of Rule 102 of the rule. Honestly and professional conscience oblige me, however, to emphasize that the defense is absolutely not in a position to do so far for the 22 of April 2002. Indeed, we need to be sure to have received full disclosure before evaluating the time. We will need to determine all the items from which we will raise a challenge of admissibility. We can state that we have, of course, already started this very important work concerning the items that are already in our possession. The preliminary challenge of the admissibility of certain elements of evidence to be used in the trial is, in my opinion, a delicate task which requires the utmost attention but also a lot of measure. This is the way I see this kind of problem. I'm aware that the case of Mr. Shala is neither the most voluminous or even the heaviest of those that your chamber and the court have to deal with. Some may even consider that the case is a small one in comparison to the other, and this distinction may be at the roots of some of the difficulties the chamber has encountered in some occasion with the way of the work was done by the SPO. But I must emphasize that while the accusations against Mr. Shala are extremely severe, the questions that arise and the nature of the work to be done are of some of even the same nature. And in my opinion, in fact, fundamentally the same as those that arise in the other heavier cases as the court has to deal with. So we are busy managing with a lot of information containing in a lot of documents, whose disclosure has not always been without difficulties. I should add that the knowledge and the study of some of this information reveal surprises of which the admissibility problem are really part in. And I provide just another example of the difficulties we have to face in this exercise. More specifically, sometimes the news and the media reveal some relevant and possible highly interesting information that could make their way into the admissibility discussions. I guess Your Honor is well aware of the recent report regarding a plot, a so-called plot against Mr. Dick Marty, who is the author of the report at the origin of the establishment of the KSC. This plot is reported as one plot made by the Serbian intelligence with the aim to fabricate or to forge some so-called evidence and to put the blame on the Albanian or the Kosovo's leaders. So this is one information, but really this is such an information was some day ago absolutely unexpected, and now we have to deal with. This is an example that the difficulty we have to deal with. This even could raise similar question to the ones that seems to appear in the case of Mr. Shala. It means, and that's what we have to face, some potential fabrication or forgery of information, materials, evidence, with the aim to implicate some individual in some crimes. We were on the ground in Kosovo, and we have the surprise to understand some things, to see something, to hear some things. We have, of course, to control, Mr. President. I don't want to cry, there is a problem or something like that, but really that's a big deal. We need, of course, some time to try to be fully aware about such an information, because it could lead to raise a problem of admissibility of some element, of course. So, in this condition, what can I say more about this without the risk to be too long? All these explain and justifies that in the current state of things, and without having yet been able to read pieces and items that must reach us, or have just done so, we cannot, whatever our goodwill, commit to a date for the drafting concerning the question of challenge of admissibility of some material that have been disclosed on the basis of Rule 102 of the rule. However, if you ask for a simple declaration of intention about a possible challenge of admissibility, I don't need more time, of course. I will, and we will challenge some of the items disclosed by the SPO on the basis of Rule 102 of the rules. If, however, Your Honor expect a full detailed explanatory inventory of our future challenges on an individualized basis, I would invite Your Honor to accept to address this matter after the SPO has fully completed its disclosure obligation. I hope I was not too long, Mr. President. Thank you.
Thank you, Mr. Gillissen. Can I take from your oral submissions that you do not oppose the two SPO requests to amend its notice? That's what I understood from your submissions, but just to be clear that both for the one that has been filed in writing and the one that has been presented orally. Mr. Ayouni.
Yes, thank you, Your Honor. We confirm we do not oppose. Part of the material that is listed is either cleared sources or things that or items that we have requested or originated the production of. So we will not oppose it, of course, with the reservation that we need the time to put it in context and analyze it. One specific but important point I wanted to return to on the document from 2010. Your Honor is aware, our colleagues of the SPO are aware that we have made a very clear request from the outset that these documents as a unit, case files with reference numbers, could be communicated to us in their entirety. What troubles us in one of our inter partes meetings with our colleagues and finally in writing in paragraph 10 of the submissions of our colleagues is that they seem to understand that it is sufficient to list items from this case file or reference number for them to fulfill their duty on the point, where we have made a clear and unequivocal request to access those documents. This is an example. This is part of that one of the units that Your Honor is very well aware of without needing to mention the specific case number. Our request is not only to add it to the notice, but to receive it. Now, I hear our colleagues saying that every item from that case file was either disclosed or listed, but this is not enough for us. We want to make sure, because the descriptions and the reference numbers are not sufficient to identify that this item is part of that case file. That's why we made the general request. And this is the case for this case number, another case number, and at least 3 other investigations, one of which is of high importance because it directly relates to Mr. Shala. So we repeated and put it on the record again. These documents, we need to have them, not have them listed in the notice, because we can still miss them. And Your Honor has noticed, the SPO have mentioned it. We have requested some items that were not re-described, or for which there is no updated description. And this is what we explained to Your Honor in the previous 2 or 3 conferences. As we advance, we can make links between numbers, we can make links between names, and as we read the material that is disclosed, the relevance becomes apparent for some other items. Since we are reviewing this notice, we identified those that are clearly relevant to us, in addition to those where new description allowed us to identify the relevance for us. So we believe we are justified in making this request, and those are the necessary points we needed to make, especially on the case files that need to reach us, not just be listed. Thank you, Your Honor.
Thank you, Mr. Ayuni. If I understand correctly, you spoke both about the 2 SPO requests and about another matter for which I've already ruled. So for the matter for which I've already ruled, then you can present a request for certification, but I'm not gonna, or request for reconsideration, but this matter is now set because I've already ruled on this. But is it correct? Do I understand you correctly that you were making reference to?
Your Honor, the point was about one item that was subject of the request. So we don't object to the SPO adding those items to his new notice, updated notice, but we make one specific point about documents belonging to one case file. Our request, previous request from the first deadlines, was that whenever the SPO has documents belonging to certain numbers that we specified, numbers of case files, then they should communicate it to us, not just list it, regardless of their request of today or Your Honor's ruling. On the request to update the notes itself, we say we don't object, Your Honor, and regarding your ruling, we are not moving to challenge it. We are just making points on the smooth communication and to avoid any misunderstanding, to put it on the record. That's all we are trying to do. Thank you, Your Honor.
Thank you, Mr. Ayuni. Mr. Prosecutor.
Yeah, Your Honor, first notice that Victims' Counsel is now back. Yes. Well, Your Honor, with regard to the issue of listing versus disclosing, the procedural framework provides for a system whereby we either choose to use a certain document in our case, and therefore we disclose it pursuant to Rule 102, or else we list it in the notice, and then the defense may request it. So if there is to be a deviation from that procedure, we can consider it if Your Honor wishes us to do so. But as I stated earlier, we believe that we have now either disclosed, because pursuant to Rule 102, or listed all the items in our possession belonging to these case files. Other than that, Your Honor, I have nothing further to add.
Thank you, Mr. Prosecutor. Nothing to add on the defense bench? Mr. Ayuni.
Sorry, Your Honor, very quickly. We have made the selection, the indication from the notice, based on a part of the case file, to tell them, regardless of the individual selections, we need everything from that case file. And this has been acknowledged from our colleagues. I believe they have done their best to do that, but we have made that selection to avoid any delays everything belonging to such case file with such number was requested out of the notice. So we are not inviting anyone to deviate from the procedure. We are just making it simple to treat it as units when they are complete units to be treated together. That's the point we want to make. Thank you.
Thank you, Mr. Ayoni. I will rule on these two requests at the end of the hearing. Let us now move to the Rule 103 material. In its written submissions, the SPO indicated that since the last status conference, it has disclosed the document pursuant to Rule 103 in Disclosure Package 42. According to the SPO, with the exception of materials currently subject to pending requests for protective measures, no other documents now remain to be disclosed to the defense pursuant to Rule 103. I invite the SPO to confirm that it has finalized its review and that all the Rule 103 material has been disclosed to the defense. Mr. Prosecutor.
Yes, Your Honor, I can confirm that. Thank you.
Thank you, Mr. Prosecutor. Mr. Gilisen and Mr. Ayoni on the exculpatory material.
We take note of the confirmation, Your Honor. We appreciate it. Thank you.
Thank you, Mr. Ayoni. So I will now consider that this category of material has been fully disclosed. Finally, let us now move to the Rule 107 material. On 6 April 2022, the SPO filed an application pursuant to Rule 107.2, informing myself that clearance had been denied to disclose a number of documents of marginal relevance to the case and cumulative nature, with all the documents already disclosed to the defense. According to the SPO, there are no additional Rule 107 documents for which clearance remains pending. I inform the parties that I will issue a written decision on this request in due course, and I invite the parties to take the floor if they want to add anything on this issue. Mr. Prosecutor.
Nothing further, Your Honor. Thank you.
Thank you, Mr. Prosecutor. Mr. Gilisen.
Yes, Mr. President, we take note. We just take note. Thank you.
Thank you, Mr. Gilisen. Let us now move to the issue of translations of filings and evidentiary material. In its submissions, the SPO indicated that it has completed the translation and transcription of the materials generated during its recent investigative activities. However, the defense indicated in its written submissions that the translation of certain items has not been disclosed. I would like to hear the parties on any further issues regarding translations. I also invite the parties to clarify if the problem faced by the defense is a disagreement related to the extent of the translation obligations of the parties. Let me start with the prosecution. Mr. Prosecutor.
Yes, Your Honor. As I mentioned earlier this morning, we will be disclosing today 6 documents, translations and transcriptions that were requested by the defense. We have received yesterday an email where the defense helpfully summarized the issues that they consider to be outstanding with regard to disclosure, and I understand that may also contain some translation-related issues. We will be tending to that document without delay and provide the defense with what we believe it is our obligation or through courtesy to provide.
Thank you, Mr. Prosecutor. Mr. Gilisen, please.
Thank you, Your Honor. As you know, we have at our disposal 3 sources of translation: from the registry, from the prosecutor, and from our own resources. And I have the pleasure to state that we don't have any problem now of translation, and I want to thank the registry and the SPO about that. Really, it's a very nice situation. Thank you.
Thank you, Mr. Gilisen. Mr. Nielsen, do you want to add anything or flag any remaining issues regarding translations?
No, thank you, Your Honor. I can just confirm that there are no outstanding prioritized requests for translation as far as registry is concerned. Thank you.
Thank you, Mr. Nielsen, and I'm glad to see that the issues have been resolved. Let me now move to the next item in our agenda, which is the status of the SPO's investigations and next step. In its submissions, the SPO indicated that it has recently completed a number of additional investigative steps and has requested disclosure of the materials generated through these investigations. The SPO specified that at this stage, it has not determined the need for further investigations. So I invite the SPO to give an update on this matter and to confirm that no further investigations are expected at this stage. Mr. Prosecutor.
Your Honor, I can absolutely confirm that with the caveat that we've included in our written submissions. If we could briefly go into private session, Your Honor, to update Your Honor on a little change in circumstances concerning something we informed Your Honor about in the past. Nothing, it will take a very brief time.
Madam Court Officer, can we move to private session, please?
Your Honor, we are now back in public session.
Thank you, Madam Court Officer. Mr. Ayouni, do you wish to respond to the other points mentioned by the SPO in its recent submissions?
No further points to make, Your Honor. We have made the slight points we needed to make. Other than that, we responded to the original request in writing, and we'll continue to monitor it that way. Thank you.
Thank you, Mr. Ayouni. For the next point on the agenda related to defense investigations, we'll turn to the defense first, as usual. I note from the defense written submissions that it is in the process of carrying out its investigations, but due to the significant delays in the disclosure process, the defense is unable to indicate the anticipated duration of its investigative activities. I also note that the defense is again not at this stage able to confirm whether it will make any request concerning unique investigative opportunities, and whether it will provide notice of an alibi or any other grounds excluding criminal responsibility. In its written submissions, the defense confirmed its intention to file a pretrial brief, but indicated that at present it is impossible to provide an indication as to when it will be in a position to do so. The defense indicated that in any event it does not anticipate to be able to do so before mid-September 2022. The defense submissions on its investigations have roughly been the same for practically a year now, despite having now been disclosed most of the evidentiary material, the SPO pretrial brief, as well as the Rule 109C charts. At the last status conference, I set the tentative date for transmitting the case file to the trial panel to 31st May 2022. Let me be clear, I do not intend to suspend the deadlines indefinitely. The parties have to work harder and faster, and the case has to be transferred to the trial panel in a reasonable time. I understand from its written submissions that the defense considered that 31st May is premature, notably given the late disclosure from the SPO. However, in its written submissions, the defense does not clearly request a new deadline for the remainder of its pretrial obligation, even though I specifically indicated that any request for postponing the tentative deadline for transmitting the case to the trial panel must be based on compelling reasons. I intend to issue an oral order at the end of this hearing in order to set an updated procedural calendar, set a date for the defense pretrial brief, and set a date for the transmission of the case to the trial panel. I will not change this calendar proprio motu. It is up to the parties to demonstrate that they need more time to finalize their pretrial work. So I expect the defense to indicate whether it is making a request to vary the current deadlines set previously, and if so, to explain in detail the reasons to delay the current procedural calendar and to indicate how much time they need for each step before the transmission of the case to the trial panel. And this applies to the time needed to make their final Rule 1023 requests, if any, the time needed to finalize their investigation and to indicate if they will make any request concerning unique investigative opportunities and whether it will provide notice of an alibi and or any grounds excluding criminal responsibility, and the time needed to prepare their pretrial brief, if any. So I invite the defense to indicate if they need more time to prepare their oral submissions on the procedural calendar, in which case I can break for 15 or 20 minutes for the defense to prepare their oral submissions. Otherwise, I invite the defense to provide their oral submissions on the procedural calendar immediately. Mr. Gillissen or Mr. Ayouni, do you want to break to prepare your oral submissions regarding the calendar, or are you able to present your requests, if any, now?
Mr. President, I think I have the possibility to explain our position first by oral, and then to have some time to make a submission by writing. I think so, but if you agree, I'm able to present some first steps about our position.
Mr. Gillissen, I'm afraid to say that I don't agree with this. I have set a procedural calendar in the last status conference. For the moment, this calendar stands. It's up to the parties now to demonstrate a compelling need if I need to change the deadlines. I will not suspend the deadlines like this. There is a procedural calendar. I am very understandable of the defense constraints, also of the last SPO disclosures, which is very unfortunate, especially because we are more than 2 years after the indictment has been filed. We are more than 1 year after the accused has been arrested. So I hope this is really the end of the disclosure phase. We shouldn't be there at the moment, but I say it very clearly, I will revise the procedural calendar during this hearing. I will not postpone this. So if you need 15, 20, 30 minutes to prepare your submissions, I will gladly give you that time, but I expect you to present your case, to postpone the deadlines, and to tell me when you will be able to file your pretrial brief, how much time you need to finally answer the question about unique investigative opportunities, to finally answer the question if you will present an alibi or not. I've asked these questions, I think, 7 times since the beginning of the proceedings, and it's been like that for more than a year. We are all bound by the requirement of reasonable delay, and I intend to enforce it. So let me be clear, we're not going to leave this hearing with all the deadlines suspended without knowing where we are going, and with the accused not knowing when his case will be transferred to the trial panel. So I think I've been clear. Mr. Gillissen, I can break for 15, 20, even 30 minutes if you wish.
First of all, Mr. President, I just have to say we have a position we are able to explain about a unique investigative opportunity. We don't need time or something like that. There is no difficulties with that. And it is exactly the same. That's why I prefer to explain it by oral, of course, for the exclusion of responsibility. There is no need of that. It's not a problem. And I can state just now, those points for us are over. That's sure. For the rest, of course, I accept the opportunity to make a written submission and to answer to all the questions and explain the position of the defense. Yeah.
Mr. Gillissen, thank you for these 2 points. This is noted, both for the unique investigative opportunities and for the defense of alibi and grounds excluding responsibility. For the procedural calendar, I would like some oral submissions, so I can break for 20 minutes, half an hour, and I will give you the floor when we are back, but I expect oral submissions today.
Yeah. Just one thing. I didn't tell you about alibi.
Sorry, excuse me. Then I withdraw what I mentioned for the record. This is for unique investigative opportunity and for grounds excluding responsibility, but not for alibi.
Exactly, Mr. President.
Thank you. This is clear now. This is very clear on the record. Shall we break for 30 minutes, and I will give you the floor to present your request for the procedural calendar afterwards?
Very nice of you. Thank you.
So it is now 10:35 Hague time. We will have a break and we will reconvene at 11:05. The hearing is suspended.
All rise. All rise. Please be seated.
So, Mr. Gillissen, your submissions on the procedural calendar.
Yes, Mr. President, thank you very much. Your Honor, I am a little bit astonished about the pressure put on us. This file about Mr. Shala starts some years ago. During some years, the SPO has the possibility to prepare his case. That's normal. It's fair. And we are in charge of this case almost till one year. And I'm a little bit astonished and disappointed that you seem to think that we are not working very hardly. Of course, it isn't. It is not the case. We do have to face a lot of difficulties. First, with the disclosure of the material of the SPO. And you know perfectly well, they has a lot of difficulties. Even now, the disclosure is not finished. More than this, the prosecutor asked to add some witnesses, some new witnesses. And it seems that you are putting the pressure on us. So we start with investigation. You know the real difficulty on the spot to be able to organize some team on the spot in the ground or on the ground to deal with investigations. We start our investigation. We were in Kosovo 2 weeks ago, I think so, yes, 2 weeks ago. It was very fruitful. And we discovered some astonished and surprising things, but not so surprising, because when we were reading some information provided by the SPO, we have some bad feelings about some witnesses or some elements, even material elements. And on the ground, we met some people. We were in these famous cookies factories, and we will discover a lot of things very, very, very interesting. That's why we have the intent to continue our investigation even during the trial phase. Now we are able, that's sure, because it's a delicate business, of course, to take position on some issue when necessary diligence has been made, we are able to say that about this famous condition of responsibility we told just before. No question to raise something like that, some question about that. We are more than 20 years after the facts, the alleged fact, with all the difficulties about the people. You know, you are well, perfectly aware that some people died. Some witnesses of the accusation died. It is exactly the same situation for the defense, of course. When we are going to the Veteran Association, to the government, to the people from the KLA, because we are obliged to speak with these people, of course. They are unable to provide documents. These documents existed, but they don't exist now. Because the passage of the time. And in 1 year, you really think, are you really thinking that we are able to provide and to put a pre-trial brief we just receiving the SPO pre-trial brief some days ago. And when I read this pre-trial brief, I discover a lot, dozens of names of people. We are not really aware about that. We have, of course, to check, to control, to investigate about that. I consider that's really a real problem of necessary diligence about that. Moreover, all of us, there is nothing to hide, are aware we have a huge problem, that's not an issue, a huge problem with the body who is shown as body of a brother, the brother of an important witness. So we had contact with some forensic experts, real one, not my friend or the friend of Mr. Awini, real one, international experts recognized as very competent, and we are waiting for the result. And of course, the defense of Mr. Shala depends on the result of these forensic answers, as a lot of things. We are seeking some very astonishing element. The most important witnesses against Mr. Shala change a lot of time his statements. And we are very, very astonished that the investigators even didn't ask him why. Why to change so many time of statements? And we have to control the links between these chains, the life of this witness and the other people, including in the pre-trial brief of Mr. Prosecutor, and we discovered a lot of things. When things evolved for this witness and for two other ones, the statement evolved too. So really that's more than a big problem, and to ask us to take position about admissibility, to take position about some so important thing as a pre-trial brief. At the moment that the prosecutor even doesn't finish to provide us with his own information, that I consider unrealistic. And when we will receive all these documentation, all these statements, all these items, all these elements that the prosecutor has, and it's his right, of course, to provide and to use during the trial, the problem for us is not to receive it. Okay, we have. No, we have to read it. We have to analyze it. And I can say that we work more than a lot, very hardly. And it's not a question to work hardly or not. It's a question to work accurately. And really I can say that's what I told you just before. The case of Mr. Shala could seem to someone to be a little one. Even, I suppose, if you compare with other cases, a tiny one. It's not. It's really an error to imagine that we are able to deal with this case without the obligation to meet all the kind of difficulties that in the other case the defense, and according to me, and the judges, has to meet. So I consider we work a lot, we work hard, but we obtain some results. And that's why I don't want to bargain time. It's not a question of bargaining time. I don't need that. There is no reason to make anything. I consider that when the prosecutor is able to close the disclosure, and in my opinion, I take a look at the prosecutor, he doesn't need many time. We are at the end of the process, I think so. So, to have the possibility to obtain our forensic expertise result, to have the possibility to close the more important step of our investigation. And you are able to imagine we don't need more months and months. It's not a question of that. So, and to finish first the reading, and some time, everybody must understand that the obligation to proceed to a rereading of documents. Because that's really the big problem we have to face now in the disclosure. Then when we receive some new documents, okay, there are not some new documents, it's not a huge difficulty. But when you read it, and you read something very strange with what you read 2 weeks or 2 months before, you're obliged to reread, I don't know if the word exists in English, I suppose it exists, to reread it and to make some links. And sometimes it's very delicate to make some links, because you know the defense counsel. They're able to build big story and to say, oh, it's a scandal and so on. No, I don't think there is no scandal. There is a very difficult situation. And to understand all the elements of, and you know perfectly well about what I'm trying to explain, war crimes. We are in a matter that's war crimes. It's not a simple deal of drug on the street. That's really a big and real difficulty. And we know in which situation, after a no presence of Mr. Shala during a long time in Kosovo, what was really the situation of Mr. Shala when he was in Kosovo in 1999. Very difficult. And I don't talk about the people we met. I talk about the witnesses of the prosecutor. They say something very different. All of us, all of them, I'm sorry, all of them explain something very different. So, no question for us. It's a question of professionalism to accept to go to the trial in this stage. It's not a claim, it's not a, I don't say it's a shame. No, just we need some time, I think, but with a very realistic vision of the things, that we could be able to continue to work during May, June, July and August. And I don't have the intent or even the idea to ask for more time. I think we could be able to file, but it depends on the time to receive all the disclosure from the ESPO, of course. But I just state before, in my opinion, we are at the end of the process. So if I don't commit a mistake, and I hate to commit a mistake, because if I commit a mistake, you commit one too, of course, because of me. So, in my opinion, we could really be in position to issue a document about the challenge of admissibility for the beginning of September. What I call, I know it's not exactly the situation, but what I call the end for all of us of the recess. Because we, of course, have the obligation to work during the recess. And I'm afraid to say that I avoid my holidays. No holidays, of course, when you deal with such a case. So, and it seemed to me at mid-September, we must be able to issue a document as a real pre-trial brief. I think it's reasonable, I think so. I don't know if I have to add something. I try to be very accurate, and you know it's not always easy for my poor little English. Thank you very much, Mr. President.
It is very accurate. Thank you very much, Mr. Gillissen, for these very detailed submissions. Mr. Prosecutor, on the procedural calendar.
Your Honor, just a few remarks before we state our position on the timeline variation sought by the defense. We, Your Honor, disclosed the core of our case before the end of summer 2021. Our case has not changed. So certain investigations, for instance, a trip to the metal factory, could have been undertaken at the time as well. Differences or claimed differences in the statements of our witnesses, if existing, they have been known to the defense for some time. Additional investigations that the SPO has had to conduct recently, as explained in our written submissions, were the outcome of an unforeseen event. But we want to state clearly, and for the record, that they had no new facts to this case. The case of the SPO has not changed, and it will not change if Your Honor will decide to allow the SPO to disclose these additional statements. Finally, when it comes to our Rule 1023 notice, I don't think it should be an issue here, because we always abide to our obligations in that regard. When it comes to the challenge on admissibility, while we, of course, understand the needs of the defense to scrutinize the evidence that we intend to rely on for our case, that can also be done at trial, Your Honor. There are procedures to take issue with the admission of documents in written form, or to object to the admissibility of documents that the SPO may choose to tender at trial. So we don't see that as an obstacle for the proceedings to go forward. Having said that, Your Honor, what Mr. Gillissen is describing now, the difficulties that they're encountering, the challenges that we all encounter in preparing a case for trial when the facts happen more than 23 years ago. It's the work that needs to be done in a case for in a war crimes case, and that we all have. These are challenges that we all have to face. On this basis, Your Honor, I just wanted to ensure that the record was accurate, but we do not oppose a reasonable extension of the time that the defense will be given by Your Honor to prepare their case. We just wanted to clarify that certain steps, for instance, the admissibility of evidence, is not something that needs necessarily to be finalized now at this stage, and that, again, while there has been some disclosure in the recent months, the core of the prosecution case has been disclosed months ago. That hasn't changed, and it will not change if Your Honor allows the prosecution to disclose the statements that we're now seeking to disclose pursuant to Rule 1022. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Just before I give back the floor to the defense, can you remind me the date of your pretrial brief?
Your Honor, I believe it was filed on 28 January 2022, but I will double check now.
Thank you, Mr. Prosecutor. Mr. Ayuni, please.
Thank you, Nora. That was the date it was filed before you, not before us. So, but One specific point, Your Honor, about the pretrial brief and about what is intended to be used in trial. We have dozens and dozens of names and details in the pretrial brief, and I think we mentioned that in the previous hearing. People who are not listed witnesses or not listed victims, for which there is evidence and for which there needs to be investigation. We should not limit ourselves to the number of witnesses proposed by the SPO, because some of the names, some of the individuals, some of the details have been explored by the SPO. And that's where the notice is important for us. The links, the evidence given by these names, by these individuals, or about these individuals, is something that needs to be in the scope of our investigation analysis for us to take those positions. It's not what the SPO has chosen to call or not to call. Even this decision-making is for us subject to investigation and analysis. Why you mention a certain fact or a certain individual in the pretrial brief, you have interviewed this person and you're not calling him. It's also something to explore. So all of these have to be taken into account in order to determine what Mr. Gillissen accurately described as the huge number, the huge volume of work that we need to do before we take certain positions in a diligent way. This is the point we wanted to say about the core evidence and the rest. What is core for us is probably different from what is core for the SPO. Thank you, Your Honor.
Mr. Gillissen, please.
Just one more thing. That's just an example, but you have to understand it. We asked to the SPO some documents on the basis of the list, documents that the SPO don't have the intent to use during the trial. And it's very astonishing document for us, for Mr. Awini and I, because that's Serbian document in Serbian language. I have to confess, my Serbian is a very poor one. My English too, you say, okay, but that's really a very, very poor one. So we don't have a translator in Serbian. I can say this is an element of the defense team, but I can't say that we asked Mr. Shala to read the document because he is able to read the document in Serbian. And he explained us a lot of things. Very interesting, but very astonishing things about some forgery, including the document itself. Some witnesses spoke about some forgery and so on, and so on. You are able to imagine, I appreciate Mr. Shala a lot, but I want to be sure to have a translator in place, to have a real translation of the document. It takes a lot of time. What I told you, it was the news of yesterday. So that's why it's a huge difficulty to work properly in a defense. But I told you there is no reason to make anything and to make something idiot. I pretend, I have stated that I don't make, and I think that nobody in my team of defense makes some idiot things. I think so till now, Mr. President, till now. But I hope to continue. I hope to continue. Thank you very much.
Thank you, Mr. Gillissen. Mr. Prosecutor.
Just very brief, Your Honor. Again, we do not oppose an extension, a reasonable extension, but the names that are in the pretrial brief did not come out of the blue. They are included in evidence that was disclosed before the filing of the pretrial brief. Thank you.
And correct me if I'm wrong, I think the confidential redacted version of the pretrial brief has been distributed to the defense on 31st January 2022.
That's correct, Your Honor.
Thank you, Mr. Prosecutor. Mr. Laws, first I'd like to put on the record that I've been told that there are still problems with the audio connection, not the audio to you, but the audio from you, and I think it's a problem on your end, so it hasn't been fixed, unfortunately, during the status conference. Do you wish to make any submissions on this? I will ask you to to try to tell me yes or no, doing this or that. Unfortunately, I cannot hear you. So, do I understand correctly that you do not want to make any submissions on this? This is noted. Thank you, Mr. Laws. I turn to the parties again. No. Okay. So let us move to the next item on our agenda today, which is the points of agreement on matters of law and fact. On 8 April 2022, the SPO made a filing to indicate the points of agreement on matters of law and fact with the defense. I take note of this filing and the limited number of points of agreement between the parties. I recall that the status conference of March 4th, I ordered the parties to finalize their inter partes discussions and submit their points of agreement on matters of law and fact by no later than 8 April 2022. Therefore, unless the parties wish to apply for a variation of time limit, I will consider the filing of the SPO of 8 April for the handover document. Do the parties wish to add anything on this matter?
No, Your Honor, thank you.
Thank you, Mr. Prosecutor. Mr. Ayuni, please.
Yes, one matter, Mr. President, for which there is agreement, but we need to put again on the record. We have requested from the early stages of the pretrial phase the audio-video versions of some witness interviews. We understand the SPO is working hard to technically make it possible while providing the transcriptions, but these videos are very important for our work with Mr. Shala, and so just to put it on the record that there is no request about it, but this is something we still expect to receive. Thank you, Ron.
Thank you, Mr. Ayuni. Mr. Prosecutor, do you wish to give an indication on these audiovisual materials, please?
Yes, Your Honors. Your Honor, some of the reasons why the defense needed access to these videos was a number of parts of the transcript which were considered to be indiscernible or inaudible. We have created revised versions of the transcript now, and we believe that a large part of these issues have been resolved. There are other reasons why the defense would like to have access to these videos, and one impediment we were faced with in disclosing the videos were the redactions in these videos, which made it quite difficult to crop the videos in a lot of different parts in order to ensure that the redactions, both the standard ones and those authorized by Your Honor, were not frustrated by the disclosure of the videos. Now, as Your Honor knows, we have been disclosing lesser redacted versions of these statements. We have done so with regard to with two of the witness 4734, and we will be doing so for the other witness that the defense is seeking to obtain access to the videos. So once we've done that, it may be easier for us to give the defense access to these videos. I believe that this request was made again in the inter partes email that we received yesterday. We haven't forgotten about it. We consider that we have solved part of it by providing revised transcriptions of this transcript, which were recently disclosed. We understand that wherever the need remains to be able to visualize some gestures done by the witnesses, we will be working to see whether we can, in fact, satisfy that request fully.
Thank you, Mr. Prosecutor. Do you want to add anything, Mr. Ayuni?
Not really, Your Honor. The second part was mentioned by our colleague, that is the gestures, the pointing, and the showing of some elements that need to be visualized rather than read was the second part, and that they are trying to deal with it. So we appreciate that. Thank you.
Thank you, Mr. Ayuni. At this point, I would like to ask the parties whether they have any other issues they would like to raise. Mr. Prosecutor.
No, Your Honor, thank you.
Thank you, Mr. Prosecutor. Mr. Gillissen.
No, thank you very much, Your Honor. Thank you.
Thank you, Mr. Gillissen. So in case we need to have a last status conference before the summer break, I had identified the date of Monday, the 30th of May as a possible date where the courtroom is available, but I think the defense indicated that, unfortunately, it is not available at that date. So I will inquire about the availability of the courtroom, and in case we need to organize a status conference, the parties will be consulted in advance to make sure that they can attend the status conference. So I will not ask for availability today. I will now break for 30 minutes, and I will come back to issue an oral order regarding the procedural calendar. The hearing, Mr. Yaini, you want to say something?
Just a quick reminder, Your Honor, for another, the request we made to modify the deadline at the beginning of the...
I haven't forgotten it, and it will be in an order modifying my first order that I've already prepared during the last break, and this will be issued after the second break in half an hour. It is now 11:36. We will resume in 30 minutes. The hearing is adjourned.
All rise. All rise. Please be seated.
Madam Court Officer, can you confirm that we're in public session?
Yes, Your Honor, we are in public session.
Thank you, Madam Court Officer. Before we adjourn this hearing, I will now issue 2 oral orders on the Rule 1023 material and on the procedural calendar for the remainder of the pretrial phase. But before doing so, I note the defense request to postpone the time limit for submitting public redacted versions of filings related to the review of Mr. Shala's detention. In view of the defense competing deadlines, I vary the first oral order I issued during today's status conference insofar as it relates to the submission of the aforementioned filings. Accordingly, I order the registry, defense, and SPO, as the case may be, to file public redacted versions of the following filings related to the review of Mr. Shala's detention by no later than 22 April 2022, and this is for F00152, F00171, F00177, and F00184. Having heard the parties, I will now issue my second oral order. I consider that the SPO has demonstrated valid reasons for amending its notice under Rule 1023 of the rules on the basis of filing F00170 and its oral application at today's status conference. First, as to filing F00170, I note that the documents falling in the first category were subject to restrictions under Rule 107 that have now fallen away, while the documents falling in the third category result from a request by the defense. Furthermore, also the documents falling in the second category are from 2010. I observe that there is a limited number of such documents and that they serve to provide context for evidentiary materials from another case that are already in the SPO's Rule 1023 notice. Lastly, the defense does not object to this amendment. In conclusion, I grant the SPO's request to amend its Rule 1023 notice of the rules by including the documents specified in footnotes 9 to 14 in filing F00170. Second, as to the SPO's oral application to amend its notice under Rule 1023 of the rules by including document with ERN SITF 000145740001456, I note that the application concerns one document that was discovered pursuant to a further review and that the defense does not object to this amendment. Therefore, I grant the SPO's request to amend its notice under Rule 1023 of the rules by including the aforementioned document. This concludes my second oral order. In this regard, I also note that the SPO requests guidance as whether my instruction to the SPO to seek leave prior to supplementing its Rule 1023 notice applies only to materials that have previously been in the SPO's possession but are only being notified at this stage, or whether this instruction is to be understood as a standing direction that also encompasses any new materials which may be received by the SPO in the future and fall within notice requirement in this case. Therefore, I confirm that my instruction covers any amendment of the SPO's Rule 1023 notice, whether it is the result of material already in the SPO's possession or any new material received by the SPO. Lastly, I will issue my third oral order varying the procedural calendar defined during the status conference of 4 March 2022 in view of the submissions made by the parties at today's hearing. First, noting that I authorized the SPO to further supplement its notice under Rule 102.3 of the rules, I order the defense to make any request regarding the items including in this notice pursuant to my aforementioned oral order by no later than 29 April 2022. Second, the SPO shall submit any outstanding request pertaining to the disclosure process, in particular request regarding protective measures, by no later than 6 May 2022, excluding the matter mentioned by the SPO in private session. Third, noting the SPO's application for an extension, the SPO shall, with the exception of material subject to any request regarding protective measures or otherwise requiring judicial authorization, complete all pretrial disclosure obligations by no later than 27 May 2022, and shall submit a notice in the record of the present case providing a detailed overview of the entire disclosure process by the same time. The defense shall, pursuant to Rule 95(2)(e) of the rules, submit any objections to the admissibility of evidentiary material that has been disclosed on the basis of Rule 102 of the rules by no later than 22 July 2022. In this respect, I note that the SPO has virtually completed its disclosure under Rule 102(1)(b), 103, and 107 of the rules, while it has disclosed a significant amount of materials under Rule 102(3) of the rules. In addition, the defense indicated that it has commenced its assessment regarding the material already within its possession. Lastly, this is without prejudice to the right of the defense to challenge any evidence at trial. Fourth, the defense shall provide specific details as to notice of an alibi by no later than 1st July 2022. Fifth, the defense shall submit a pretrial brief, if any, by no later than 15 August 2022. In this respect, I observe that the defense refers to the volume of disclosed material in arguing that it cannot submit its pretrial brief before mid-September at the earliest. However, the defense has been in the possession of a significant amount of disclosed materials, the pretrial brief, and the Rule 109C charts for some time, which means that it has had a significant period of time to assess its position. In addition, I note that pursuant to Rule 95(5) of the rules, the defense, should it choose to submit a pretrial brief, shall indicate the accused defense in general terms, the charge and matters disputed, and the list of potential witnesses without prejudice to any subsequent amendment. Lastly, I set the tentative date for transmitting the case file to 31st August 2022. This concludes my third and final oral order. And this concludes today's hearing. As usual, I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technician, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.